Good afternoon and welcome to the American Bar Association's Tort Trial and Insurance Practice. Today's program is entitled COVID-19, Furloughs, Workshare, Layoffs, PPP, What to Do and How to Do It. Brought to you by the TIPS Leadership and Council. TIPS is known for its quality programming, and today is no different. With the state of the current affairs and uncertainty around the pandemic, bringing today's complimentary interactive webinar to discuss the pros and cons of the program like this and the best practices as managers contemplate furloughs and layoffs in the short term is exactly what we need. While today's program does not have any CLE credit, we hope that you find it useful and relevant to your current situation. This forum is not like a traditional program. We encourage attendees to ask questions throughout the program, and upon entering the webinar, you will automatically be muted. However, if you would like to ask a question, please request access to speak, and the host will unmute your line. If you choose to pose your question in a written format, please send the host, Tort Trial Insurance Practice, your question via the chat box, and they will be sent to the panel. It is now my pleasure to introduce the moderator for today's program, John McMeekin from Rowell & Henderson. John, you may take it away.
Great, thank you, Jewel. And to ladies and gentlemen who are presenting and to those who are attending, I'm sure you've heard this many times in any given day, but we are in uncharted waters and unprecedented times where law firms and our clients are for one of the few times in history talking about the same things, and those same things are our cash flow and how do we provide for and ensure the future of our firms, our clients, our employees, and in some cases our family members who work with us. So this presentation today is designed to be a roundtable. The presenters have significant experience in working with furloughs and workshare programs and layoffs, but very candidly, no one has extreme experience in the PPP loans and how the Small Business Administration will be administering. And for that reason, we expect that there will be a lot of questions. John and Laura have spent a lot of time researching the PPP, but we welcome if you have a different perspective or if you have heard something different, that we can use this opportunity to share best practices and to do what we can to get the economy back up and running, to ensure that our law firms and our employees are given the best opportunities they have to successfully come out of the COVID crisis. I am the chair-elect of the TIPS section of the ABA, and this is a presentation that Thea Capone, as the chair of the TIPS section and the other leadership, thought was incredibly important to make available at a no cost but no CLE credit opportunity for everybody. So please do chime in when you have a question. We have about an hour and a half reserved for this. I'll let each of the speakers announce themselves and tell you what their particular area of expertise is. But I think everybody has agreed in participating in this that the key really is to convey information and try to respond to whatever unique situations you may have that go above and beyond the prepared materials. So with that, I will turn it over to the first presenter. Kay, I believe you're the first presenter?
No, I believe it's John.
Oh, John. Sorry, John.
No problem. Good morning, everyone, or good afternoon, whatever the case may be. My name is John Kreitzer, and I'm a shareholder at the Portland office of Sullivan Hauser. I'm broadcasting to you live from my home office in my basement on top of a ping pong table in Portland, Oregon. I'd like to thank ABA TIPS for asking me to present. I'd also like to thank ABA TIPS for not showing my picture while I do this presentation, because frankly, it's getting a little rough. I also like to thank Kay Hodge, my co-presenter on the first topics, for preparing the PowerPoint slides and taking the laboring war for that. What I'm going to talk about this morning is the Family's First Coronavirus Response Act, the FFCRA, not to be confused with FCRA, which is the Fair Credit Reporting Act. The Family's First Coronavirus Response Act was signed into law by the President on March 18th, 2020. It became effective April 1st, 2020, and will run through the end of the year, December 31st, 2020. The regulations can be found at 85 FR 19326, and those came out just recently on April 6, 2020. They are about 32 pages long, and they're very informative. Your best resource, frankly, for answers to the many questions you may have about the FCRA can be best found in those regulations. Pardon me. And there's a link below to find those. The federal regulations were just corrected 4 days later at 85 FR 2156. And so there were some changes about a number of things, but one of them had to do with whether you can require an employee to take paid leave as part of the EFMLA, and I think Kay will get into that a little bit later. Kay, next slide, please.
I'm trying to make it work.
Very well.
It's not moving forward, I'm afraid.
Well, I'll just keep going and we can catch up.
Yeah.
So who does the FCRA cover? It covers private employers with 500 or fewer employees. And that includes all full or part-time employees, employees that may be on some sort of leave. It covers joint employees and employees of integrated employers. An example of that may be two dentists that share an office and share employees. So a person may be employed by both, and so you would count all the employees of those integrated employers for purposes of making a determination of whether you have 500 employees. I've never seen a dental office with 500 employees. Maybe that was a bad example, but that was an example of an integrated employer. To count the number of employees, that doesn't include independent contractors, workers that have been laid off or furloughed and that have not been reemployed. FCRA also covers public sector employers that have at least one employee, and it doesn't exclude some federal employees. Okay, next slide, please. There are coverage limitations. An employer may exclude healthcare providers and emergency responders from coverage from the emergency paid sick leave and the emergency family medical leave. And there's another important exception for very small employers, and that is an employer with fewer than 50 employees may be exempt when the imposition of the emergency paid sick leave or the emergency family medical leave would jeopardize the viability of the business as a going concern. That requires certain representations from the employer to document that not providing those leaves would jeopardize the viability of the business. So the Family's First Coronavirus Response Act provides for emergency paid sick leave, which is a paid leave, and emergency family medical leave, which is actually another paid leave, where normally the FMLA, the Family Medical Leave Act, provides for unpaid leave. the FFCRA does not apply to employees who are working or are able to telework. When an employee is teleworking, the employer is only obligated to pay for the actual hours that the employee works. And this is a change under the FLSA. You're not required to count all the hours between the work periods from when the employee starts the workday and ends the workday. You only have to pay them for the actual hours worked. This is really applicable to non-exempt employees that are paid hourly versus salaried employees. Salaried employees, you have to pay them their salary while they're teleworking, whether they're working overtime or less than full-time. But under the FLSA, normally, like commute time between when you start your workday and end your workday is all compensable. This is not the case under the FCRA. Okay, next slide, please. Okay, so what is the emergency paid sick leave? The emergency paid sick leave under FCRA provides for 80 hours, and that is 2 weeks of emergency paid sick leave for, and this is critical, this is for employees who are unable to work or telework because of COVID-19, and it's applicable in 6 situations. If you are a part-time employee, rather than the 80 hours, which is the equivalent of the 2 weeks pay, you get the part-time equivalent for that 2 week period. And that's based on the average hours that you worked in the prior 6-month period. EPSL is based on the employee's regular rate of pay. So for those 80 hours that they are receiving the EPSL, you're paying those 80 hours at the employee's regular rate of pay. Okay, next slide, please. So what are the qualifying reasons for which you can take EPSL? Again, and I'm probably going to repeat this many times, it's an employee who is unable to work or telework, and for these 6 reasons. The employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. And again, I'm in Oregon, and I think that's applicable to me. We all have a stay-at-home order, so I can't go to the office. So I am subject to an isolation order from the state of Oregon. I'm not qualifying for the EPSL, however, because I am able to work or telework remotely. I've got my 2 monitors and my laptop and my docking station all set up on my basement ping pong table, and it's just like I'm in the office. So I don't qualify for EPSL because I'm able to work or telework remotely. A second qualifying reason for EPSL is the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. I think that one's fairly self-explanatory. The third reason is the employee is experiencing symptoms of COVID-19 and is seeking a medical diagnosis. Fourth reason is the employee is caring for an individual who is subject to an order as required in paragraph 1, or has been advised to self-quarantine as listed in paragraph 2. The fifth reason is the employee is caring for a son or daughter if the school or place of care has been closed or unavailable due to the COVID-19 precautions. The caring for a son or daughter means a minor under the age of 18, and it's also applicable to individuals with disabilities. And the sixth reason is the employee is experiencing any other substantially similar condition as defined by the federal government. Going back to the regulations which give us some guidance, you're going to find very little guidance on number 6. Next slide, please, Kay. And what is the pay for employees on EPSL? You receive 100% of your pay for those 80 hours or 2 weeks for a maximum of $510 a day or $5,110 total. And that 100% of pay is when the first 3 of the qualifying conditions are met, and that is the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. The employee has been advised by a healthcare advisor to self-quarantine, or the employee has symptoms of COVID-19 and is seeking a medical diagnosis. Next slide, please, Kate. Employees on emergency paid sick leave receive 2/3 of their pay for 80 hours, or the equivalent of 2 weeks, or and to a maximum of $200 a day or $2,000 total when the conditions of what were 4 and 5 above are met. And that is if the employee is required to care for an individual that is subject to a quarantine order or has been advised by a healthcare advisor to self-quarantine. And again, that isn't limited to just the children or the people with disabilities, but it's also family members or roommates. The employee may, with the employer's approval, use his or her accrued but unpaid sick time, personal or vacation time, to make up the difference between the 2/3 pay under the EPSL and the rest of the full pay. Next slide, please. And here are some considerations for EPSL. Quarantine and isolation is broad, and it should be interpreted broadly, but EPSL is only available when, again, the employee is, when they're isolated and the employee would be, but for the quarantine or isolation order, the employee would be able to perform or telework. The employee is not eligible for EPSL where the quarantine or isolation order causes the employer's closure, which results in a lack of work. So, for example, our law firm, if we had nothing to do because all the work dried up, that wouldn't entitle you to EPSL. Or another example, perhaps better, a coffee shop that's open because it's deemed necessary has no customers because nobody's going out to buy coffee. Those employees where they could work, but there's no work to do, they're not qualifying for EPSL. The category of advised by a health care provider applies only if the employee has COVID or may have COVID-19 or is particularly vulnerable, and that advice causes the inability to work or telework. If you think you may have it and you're waiting for a medical diagnosis, but you're able to work or telework as you're sitting at home waiting for the doctor to give you that diagnosis, if you're able to work or telework in that situation, you're not qualified for EPSL. Next slide, please, Kate. When you're seeking the medical diagnosis, I think I just covered this, but the leave is limited to the time it takes to obtain the diagnosis. So if you're actually sitting there waiting in the office or attending an appointment, that would be qualified time for EPSL. But again, if you've gone to the doctor, you've taken a test, you're home and you're able to work or telework, that time wouldn't count for EPSL. And again, the care for an individual applies to folks in your immediate family, those that regularly reside in your home, or those that you have a relationship that creates an expectation of care. Next slide, please, Kate. You do receive the 2/3 pay for up to 80 hours. for a maximum of $200 a day or $2,000 total. If under the EPSL, if the employee is required to care for a son or a daughter when that school or place of care has been closed, or the child care provider is unavailable due to COVID-19 precautions, or to care for an adult son or daughter who has a mental or physical disability and is incapable of self-care because of that disability. This 2/3 pay is also applicable. Excuse me, an employee may, with the employer's approval, use, again, the accrued but unused sick time or personal time or vacation time to make up the difference in the full pay. Next slide, please, Kay. And actually with that, I'll turn it over to my co-presenter, Kay, who will talk about the expanded family medical leave under FCRA.
Hello, everyone. Good afternoon. I'm on the East Coast and John is on the West Coast, so it's the difference between afternoon and morning. My name is Kay Hodge, and I am a partner at the law firm of Stoneman, Chandler, and Miller, LLP. We are essentially a boutique labor and employment law firm representing management in Boston, Massachusetts. And so what I do for a living is I help employers meander their way through all of these various requirements, both on the public and the private sector. In any event, we've broken, or this is the, if you will, the transition point, because for the care of a child whose school or daycare or has closed, you are covered both by the paid sick leave, which John was talking about, but also one of the things that the Act did is the FMCRA added another basis for FMLA, or Family and Medical Leave. And the way in which it did it was to amend and add another reason for qualifying for FMLA. So this particular provision provides for 12 weeks of leave when the employee is unable, again, to work or telework on account of having to care for a son or daughter under 18 years of age, because their school or place of care or their provider is unable or has closed or is unable to provide the care, or to provide care to a child over 18 who is incapable of self-care because of a disability. This particular provision, and it's important to keep this in mind, is only available if there's no other suitable person to care for the child. But for the need to care for the child, the employee could work or telework. In other words, let's just assume for a moment that a person lives in a multi-generational household. There is another person who is able to care for the child, and therefore the employee might not be able to take advantage of this expanded family medical leave, EFML. Another slide. Next slide, please. Now, the 12 weeks is divided up under this particular provision into the first 2 weeks are unpaid. However, you may use the EPSL for the first 2 weeks. So you could use the EPSL that John was discussing to fill in for these first 2 weeks. Or if you have had to use it for some other reason, you can also, with the employer's approval, use accumulated leave, which is 6 personal or vacation, if applicable, to pay during this period. In addition, many FMLA policies, just going back to if you have an FMLA policy, would provide or require an employee to use any accumulated time to pay during an unpaid period of leave. Next slide, please. Okay, so what does the expanded family and medical leave provide in terms of pay? The fact of the matter is, oh, by the way, I had a question which I'd like to answer, which is whether or not an employer could provide more vacation and or paid time. And the answer to that is yes. I would be cautious about providing vacation simply because, or calling it vacation, simply because of concern that an employee may argue after they've used their 12 weeks of leave that they still have quote unquote more vacation available to them. In any event, what you have is 2/3 pay for up to 10 weeks of leave for a maximum, again, of $200 a day or $10,000 in the aggregate or total. $200 a day may very well be below what the employee would otherwise get, but it is capped at $200 a day, which may be lower than 2/3 of an employee's pay. The employer may require that the employee use his or her accumulated time, sick, personal, or vacation, if it's applicable. For example, in this instance, many employer sick pay policies do not provide for use when the child is well. Others do allow for use in a family situation. So again, it would be subject to whatever the other conditions are that the employer has placed on the use of sick, personal, or vacation. But again, the purpose of that is to make up the difference in pay. One of the things to just note, and I know that John mentioned this at the beginning, and I would note it again, in the initial set of regulations that were issued, there was a provision, 29 CFR section 826.70 little f, which provided that an employer could not implement what it could implement on all the other FMLA leaves, which is require that employees use their leave in the situation of a COVID-19 expanded leave situation. It was withdrawn 4 days later in the revised regulations or in the corrections. And let me just stop for just a moment. If you're wondering, well, why would they withdraw that? It's because one of the things that is really problematic is if an employee has been, shall we say, taken leave for 12 weeks or 10 weeks or however many weeks, and then returns, many employers find it very difficult when the next thing that the employee seeks is to now schedule their vacation that they have a right to take. And that is one of the reasons that they try to get the employee to use the pent-up time that they may have when they are taking an extended leave. Next slide. Now, when I mentioned the fact that this is additive to the Family and Medical Leave Act, that has some importance, and I just wanted to note it for other lawyers who don't practice in this area all the time. This whole FCRA is very odd. It applies to employers with less than 500 employees. Because it applies to employers with less than 500 employees, what that means is that it will apply if you had 2 employees. Consequently, since FMLA is not applicable unless you have 50 or more employees within a 75-mile radius, therefore this particular expanded family medical leave applies to employers who do not have a regular FMLA obligation. So that's important, that if you represent a small company and they say, oh, we're not obligated to apply to FMLA, that may be true, but they would be obligated to implement expanded family medical leave under the Families First Act. Another thing that is different is that the eligibility requirements is only 30 calendar days of employment. And that is much lower than what is required to be covered under the Family and Medical Leave Act. Under FMLA, you have to be employed for at least a year, and you have to have worked 1,250 hours in the immediately preceding 12-month period. That is not what is required. Here, you only have to be employed for 30 calendar days. and I understand that I have a question, but let me just finish the slide. You must continue throughout this leave, if it's 12 weeks or if it's 10 weeks or if it's whatever, to continue health insurance during that period of time and make arrangements with the employees to make their contributions toward insurance. And you should follow whatever your usual FMLA procedures are, and that would be to have documentations about designating the leave and just making sure that employees know what their rights are. And the employee is obligated to give their employer whatever notice you would otherwise require. Next slide, but I can address the question if I can see what the question is. Jewel, next slide. Oh. I'm not understanding leave reason 1. Is it 2 weeks to anyone working but subject? Now, leave reason number 1, if you're talking about the quarantine or isolation order, that is not a part of the expanded family medical leave. Expanded family medical leave only applies if you are staying home and unable to work or telework because your son or daughter, school has closed or daycare provider is unavailable.
Kay, this is John McMeekin. I have a slightly different version of that question. What happens if you are, put all of ourselves in our firm's position, we're healthy and able to work remotely, but our spouse has a problem. And now we have to take over for care of an elderly person or care of a child or care of a person with disabilities that we didn't have to before, but is unrelated to a disability or problem that we have in ourselves.
Okay.
How does the firm deal with that?
Sure. This would all devolve back to whatever your FMLA policy is. And under the FMLA, you are required to provide care. An individual is allowed to have up to 12 weeks of leave for the purpose of caring for a family member who has a, quote, serious health condition. So the question would be whether or not the individual has a serious health condition. The contrast to the EFML, which is this expanded family leave, is that the children are just not able to go to school, but they are well and do not suffer from a serious health condition.
Gotcha.
So that's really the distinction that you have. So you would have to go back to the classic standard reasons why you could get FMLA, which include, birth of a child, or adoption of a child, or it is that you yourself are sick, or you're taking care of a family member who is sick. And there are special rules with regard to individuals who are called up to military duty or individuals who are returning injured from military duty. Now, this is important, and what the question you mentioned, John, is important because there is this nexus between expanded family and medical leave and family and medical leave. And that is, you can't get more than 12 weeks of leave total in any 12-month period. So if you have, for example, taken 12 weeks of leave because you gave birth to a child back in December, and then we suddenly have now this expanded leave, you have used your 12 weeks of leave and would not be eligible for any additional expanded family medical leave under the Families First Act. Likewise, if you've used only 6 weeks of leave, you would only then be able to use 6 weeks of leave. In addition, some employers have, instead of just using, looking backwards for 12 months from the date the leave is requested, will use a specific year, like a fiscal year or an anniversary year. Note that I didn't use calendar year, and the reason I didn't use calendar year is because this particular expanded family and medical leave expires on December 31. So you're not going to go past that end of the calendar year. But let's just assume for a moment, a lot of companies have a fiscal year of July 1 to June 30. and assume for a moment that normally on July 1, you would get a brand new 12 weeks of leave, just because you get 12 weeks in each of these years. The fact of the matter is that would not be applicable in this situation, but you would count 12 weeks total. So if you started on April 1 to get, to use, or let's just say you started on May 1 to use your expanded family and medical leave, and on July 1, you would normally get an additional 12 weeks. You would not in this instance, you only get 12 weeks for this expanded family and medical leave reason. New slide. Then there are also under FMLA, one of the provisions of your policy has been you were required to provide family and medical leave intermittently or on a reduced schedule. That is not required for this expanded family and medical leave. What does this mean? Well, under the FMLA, you might be required to allow an employee to go to a medical appointment like dialysis once a week, and therefore once a week give it on an intermittent basis. Or there might be a particular condition that may flare up intermittently. That is not, you're not required to allow intermittent or reduced schedule use of expanded family medical leave. You can require, therefore, that an employee start on day 1 and take the leave continuously. However, you are allowed, by mutually agreeing and having a mutual understanding, to allow for an individual to take the leave on an intermittent or reduced schedule basis. And employers should consider whether or not that's in their best interest. It may very well be to allow an employee to sort of, take some that they have to take over into the care of the children in the afternoon, and therefore they're taking essentially a reduced schedule of half time, and half would be covered by their regular teleworking, and the other half would be covered by the reduced schedule leave. One of the things that the expanded family and medical leave provides, where the FMLA is incredibly document intense, the expanded family medical leave allows just mutual oral understandings. However, it does say that the employer should memorialize the understanding in writing so that it will be available for review. And that's going to become hugely important as I go through this, because the whole point of all of these payments, you can be reimbursed by the government and you can recover these payments. And unless you have them memorialized, you're not going to be able to do so.
Okay, can you stop there? Can
Yes.
you stop there again for a second?
Yes.
I think a lot of people are, and this will get into the PPP presentation, so I don't want to overlap, but I think a lot of people are going to be interested in knowing how to get the most reimbursement for our firms and employers and clients. And are you suggesting that the more documentation, the more likely there is reimbursement, or are you suggesting that there's the documentation is for a challenge to it down the road?
Yeah, I think it's both. I think because the manner in which you recover payments made to employees either under expanded sick leave or under expanded family and medical leave is through the employment, by not paying employment taxes. You ought to maintain as much documentation as you can. And what I'd like to do, Jewel, is to go back to, there's a reinstatement slide, and that would, there. Okay, so yes, you do need to keep documentation. We'll get there in just a second. The key to all of these leaves is that at the conclusion of either 2 weeks out on expanded paid sick leave or expanded family medical leave, is that the employee has a right to be reinstated to the same or similar job that the employee held before they went on leave. And the employee is not protected against layoffs that have affected everyone. So if in the interim, while they're taking their leave, everyone is laid off, then they would take their place and be laid off also. In addition, you should keep in mind that an employer with fewer than 25 employees may deny reinstatement as long as they follow a certain procedure, which I'm not going to have the time to get into, but can certainly talk about if someone has a question. Next slide. As with all sort of government obligations, they want you to post a notice. Well, that was interesting because most of us are being kept out of our offices. But the notice, and on this slide, it has the, the internet address where you can download the poster. But what you can do is just download the poster and email or direct mail the notice to all of your employees, as well as posting the notice on your internal and external websites and other notice boards that you may have. And then I also think it's a good idea to post it in your office when you happen to be there. Next slide, please. For enforcement of this act, and because this act is sort of added on to a bunch of other things, and because the FMLA is built on the platform of the FLSA, the Fair Labor Standards Act, it is not a surprise that both the expanded sick leave and expanded family and medical leave are sort of add-ons, and they have the same prohibitions that are extant under the FLSA or the Fair Labor Standards Act. You can't discharge, discriminate, discipline any employee for taking any of these leaves or filing a complaint or action against the employer. You also cannot, if you fail to pay, for example, either and I have here only the sick leave, but if you fail to pay the sick leave and or the expanded family medical leave, it's considered a violation of minimum wage laws and would be subject, I think, to the doubling or the treble under the potential willful violations under the Fair Labor Standards Act. So you need to know that the enforcement mechanism is extant. It's been there a long time, and by and large, it works pretty effectively to get compliance. Next slide. The Department of Labor lists in its materials all of the different information, the type of information you ought to retain. And that includes, just the names of the employees, the dates of their leave, the qualifying reason for their leave. And if it was because of a quarantine or isolation, then you need to know the name of the governmental entity that issued the order. If the reason is a healthcare provider, you've got to know the name of the healthcare provider. And if it's for an individual that's not a child of yours, you've got to list the individual who's involved, and you may need information about the relationship. And if the reason is for care of a child, then you want to know the name, the age, the name of the school or place of care or child care provider. And you have to get the representation that no suitable person is available to provide the care. And next slide.
Okay.
Yes.
Before you move to the next slide, we have a couple questions, and I want to remind you and the other panelists that we are at about the halfway point in timing. So the two questions that we've got are, and I'll read them. They are rather complicated, and you may or may not have an answer to them. The first is a client with greater than 500 employees, technically required to comply with EFML. However, they're exploring that possibility. The question is whether they can have their own version of EFML and have it counted against the FMLA 12-week calculation. Thoughts?
I don't believe they can, because I don't think that the FMLA is 12 weeks, and an individual could argue that they are entitled to the other reasons, 12 weeks for the other regular FMLA criteria, because there was no carve out, or they didn't lose any because the employer chose to add an additional Family and Medical Leave Act that mimics this statute. The statute is what allows you to use it as a part of the FMLA.
Perfect. Okay, thanks. Second question. If there is an employer policy regarding use of paid time off, PTO, concurrent with FMLA, can the employee decline that use in accordance with the law, which provides that employees cannot be required to exhaust PTO first?
Yes and no. If you are entitled to get emergency sick leave, paid sick leave under this statute, and or family and expanded family and medical, the first payer is the payment that comes through that is required by the statute. In other words, you cannot require someone to exhaust their sick time before they get the 2 weeks of emergency sick pay, sick leave. Nor could you require that they exhaust their vacation or whatever before they would get to use expanded family and medical leave. On the other hand, you can certainly require that they use their own accrued PTO to make up the difference between the 2/3, or even where the 2/3 falls lower, and their regular pay. So that's the way it would work. You would use it for that purpose.
Great, thank you, Kay.
And then the next slide lists what the IRS may require. And why does this have the IRS requirement? It's because the employee must provide sufficient information for you to receive tax credits. And these tax credits are only available to private sector employers, and they are essentially, you collect them through your employment taxes and by not paying your employment taxes. So when you pay out money for an emergency of sick leave, paid sick leave, or you pay out some of this money once a person is past the first 2 weeks of their expanded family and medical leave, then you could deduct what you've paid out from your payroll taxes, essentially. And the IRS has frequently asked questions, which I've listed them. I've listed the hyperlink in my PowerPoint. In addition, and this is a trap for the unwary, the IRS has a requirement that if a child is 14 years of age or older, then the employee must provide a statement describing what special circumstances exist requiring the employee to provide care during daylight hours. So just don't get caught into that trap. In addition, you're going to need to be able to show that there were, to describe to the IRS how you determine the amount of expanded paid sick leave and expanded medical family and medical leave that you paid to employees by having records that would describe it. You have to show, and you would have to be able to document exactly how much of what you have described on your form 7200, that's your employment tax forms, what you paid out. And there's a variety of other things that you might want to look at. And finally, there's a 4-year retention period. In other words, you've got to keep all these documents for a minimum of 4 years. And that is the Families Friendly Coronavirus Leave Act provisions. And I turn it over now to David.
Thanks very much, Kay. This is David Rosenbaum. I'm a partner at the law firm of Rowan Henderson. I am the chair of the Commercial Litigation and Transactions Practice Group, and also the general counsel of the firm. In that capacity, I've helped manage the COVID crisis for our firm, which has 6 offices in 6 states. That's been particularly a challenge.
David, you just cut me down by 5 offices. We have 11.
Sorry. As John indicated, I'm general counsel reporting to an executive committee on which he is on. One of the biggest challenges I had to deal with was rewriting our sick leave policy, where we had to deal with 6 different state laws as well as laws in particular cities. So it's been a real challenge. And I'm going to talk about the shared work programs, which are an alternative to layoffs during the COVID pandemic. As offices and courts closed due to the COVID-19, there have been significant decreases in both the demand for legal services as well as for the products and services provided by many of our clients. As of March 18th of 2020, 1/5 of the total US workforce reported losing hours or work because of the pandemic. For law firms with significant litigation practices, the combination of court closings and lawyers being forced to work remotely has resulted in lower workloads for secretaries and file clerks, not to mention some attorneys and paralegals. The challenge for businesses and law firms is to weather the COVID storm without causing long-term damage to our firms, businesses, and employees. The next slide, please. Shared work programs, which have been adopted in a little more than half of all US states, can help avoid layoffs and furloughs that otherwise might be required during seasonal or temporary economic downturns. Under shared work programs, layoffs are avoided by reducing hours and wages for employees who receive reduced compensation and partial unemployment compensation benefits, along with full employment benefits, which often include health care insurance. While shared work programs existed in the United States for years, they've been utilized more frequently during the COVID-19 pandemic. In the CARE Act, the federal government recognized the value of shared work programs as a tool to avoid layoffs when it provided funding to encourage states to adopt and promote shared work programs, as well as reimbursement for 100% of the short-term compensation paid to affected workers through December 31st. In Washington state alone, new applications for shared work plans soared, with 848 being filed during the first 15 days of March, compared to just 147 for the rest of the year. Other states, including Ohio and New York, have seen similar increases in shared work applications. Employees benefit from shared work programs because they remain employed and receive full benefits when they otherwise might have been laid off. During a pandemic, when having health insurance is so important, layoffs can be particularly devastating because purchasing health insurance through COBRA is often price prohibitive. Employers benefit from shared work programs by retaining trained and valued employees, which can avoid future labor shortages and training costs. Shared work programs have even greater significance in states like New York that otherwise only grant partial unemployment compensation for workers with lower earnings. In some states, employers with shared work plans must continue to provide full benefits, which would be more costly than if the workers were laid off. Nevertheless, many employers conclude that incurring this cost is the right thing to do, especially given the importance of their health insurance plans and the devastating effect that layoffs can have on both morale and the reputation of firms and businesses. In some states, employers must pay higher unemployment compensation costs when employees in shared work plans collect partial unemployment compensation. However, the cost may not be materially different than if full benefits were paid to laid off workers. In some states, shared work programs have eligibility requirements that include floors or caps on permissible wage and hour reductions. For example, in New York and New Jersey, employers must reduce hours and wages by not less than 20% and not more than 60%. In contrast, Pennsylvania has a maximum permissible reduction of just 40%, which ironically means that in Pennsylvania, an employer might have to lay off workers in order to qualify to file for a shared work program. Interestingly, in Europe, where shared work programs are also popular, there are often no maximum reductions to qualify for government wage support. In Pennsylvania, there's also a requirement that all employees in shared work programs must have equal reductions in their hours and wages, which could present challenges where businesses value some employees more than others, but those challenges can be overcome depending on the employees that are included in the shared work program. Next slide, please. In many states, the process of forming a shared work program starts with an employer filing a shared work plan with the State Department of Labor. In a proposed plan, employers identify the employees or business units that will participate, and in states like Pennsylvania, employers are given increased flexibility because they're allowed to have multiple shared work programs with separate and distinct participants. To illustrate a little bit about how shared work programs avoid layoffs, let's consider the following example. A law firm has 10 office workers, but its workload has been reduced by 40%. If they didn't have a shared work program, the law firm might have to lay off 4 workers who would then lose their jobs and employment benefits and be eligible for full unemployment compensation. If that same law firm had a shared work program, it could reduce the hours and wages of all of the affected workers by 40% and pay those workers the reduced wages plus their full benefits. The state would then pay those workers partial unemployment benefits, which in Pennsylvania would be 60% of the benefits that they would have received if they had been fully unemployed. According to a survey done by Politico, most businesses that utilize shared work programs are very satisfied with them. Unfortunately, many employers do not know that programs like this exist and therefore haven't taken advantage of them. The COVID-19 crisis has raised our awareness of shared work plans, both through our work with clients implementing plans, as well as our own evaluations of how they could be implemented for our law firm as a strategy for dealing with the economic challenges of the COVID-19 crisis. Thank you.
David, this is John. I have a question for you. Can you talk about how to define work groups for shared work programs where you may have small offices or small groups of people that fall into a particular category? In other words, not a lot to be a group, as compared to, say, a steel mill here in Pennsylvania. And whether or not you can cross state lines for groups for a entity that has multiple offices to get to some level that makes sense.
Okay, let me start with the last part of that question first. So shared work programs are state-specific programs, usually administered by the state offices of unemployment compensation. And so I don't believe that you could file a plan where you would cross different states. I think what you would do is you would file for a shared work program in each of the states in which you operate. Most of the laws that I have seen indicate that the employer is the party that's responsible for identifying the affected work group, and so there's flexibility in deciding who's going to be a participant in the shared work plan. And one of the other, I think, interesting characteristics, at least of the states that are in which we have offices, there's a requirement that a shared work program have at least 2 workers. So in a state like Pennsylvania, where you could file multiple plans, there's an opportunity to kind of closely define it and have multiple plans that would deal with the situation of varying workers in different sites. Does that answer the question?
It did. And one final question to follow up on that. And kind of the reason for having this program is to try to keep people employed, and if that's unfeasible, to give everybody the best chance to continue on. if you implemented a shared work program in a state that permits it, and then circumstances continue to be problematic for the employer, can you modify those programs to reflect changes in circumstances that would then require you to perhaps lay somebody off in full?
So in most of the states that I've seen with shared work programs, the program can get terminated for two reasons. One is you do something that doesn't qualify you for having the shared work program in the first place. So you lay off workers or something like that. You end up reducing hours by more than the percentages that are permitted, and then in that case the state would terminate it. In the situation that you've described, the employer would have the option of either terminating the plan or proposing a modification, and then the state, if you proposed a modification and the state wasn't willing to accept, then you'd have to just cancel your entire program. The other thing I think that would be important to talk about is that in the absence of a shared work program, there are states like Pennsylvania that permit employees who have had their hours reduced to apply for partial unemployment insurance benefits. And so it's a little bit similar to what you would get under a shared work program. The difference is that the employees have to go through the laboring or of initiating and filing the claims. In a state like New York, they don't really have that option except for the low earning wages. And so shared work programs are, as I said during the talk, a little bit more important.
Great. And David, we have two other questions. One is, can a firm with just one office have one shared work program for secretaries, another for paralegals? Second question, are employees receiving compensation under a shared work program eligible for the $600 federal unemployment benefit?
Okay, so the second question I'm going to answer first and say I don't know the answer to that question.
Okay.
The first question I do know the answer. So that would be state by state. We've actually had to look at that issue in Pennsylvania, and we successfully communicated with the Department of Labor, which was a little bit of a trick, and we confirmed that the employer in Pennsylvania has discretion to define the shared work program however it wants to define it. So you could have a shared work program for secretaries as long as you had more than two of them, and similarly you could at the same time have one for paralegals if you had more than two of them. But again, the definition of how you go about defining the affected group would vary from state to state. So you'd have to look to see whether your state would permit it, and also because plans are proposed and ultimately approved by the departments of labor, whether or not your particular Department of Labor would let you have a program for separate programs for secretaries and paralegals.
Great. One last question, then we're going to move on to Laura because time is getting short. If your state does not have a shared work program, can an employer implement shared work anyway? What law would that violate? What are the options? And we know at least two where we have practices that do not have shared work programs. So maybe you can answer.
So I guess the answer is that you could certainly reduce wages. The problem is that unless you were wages and hours, the problem is that you couldn't unilaterally establish shared work programs in a state where it didn't exist, because you need the state to be willing to pay partial unemployment insurance benefits, and unless the state expressly permits that, you wouldn't be able to do that. I did think it was interesting, and as I mentioned in the presentation, the CARES Act is really trying to encourage states that don't have shared work programs to adopt them. And even if your state doesn't have one, be interesting to see whether the federal funding that's provided under the CARES Act would result in the creation of some new programs. I suspect that it will.
Great. Thank you, David. Laura, I think we're to you now.
Event Hauser. We have offices in California, Oregon, and Washington. My practice focuses on complex commercial litigation, IP, and professional liability litigation. I want to thank TIPS for the opportunity to present today. I want to thank our co-presenters for having done such a fabulous job, tough acts to follow, and a special thanks to Jules Jones, who's done a wonderful job helping us get prepared for today. We've talked a lot about the CARES Act. Under the CARES Act, the SBA received funding and authority to modify existing loan programs and establish a new program. In my presentation today, I'll talk briefly about the Economic Injury and Disaster Loan Program and the $10,000 advance allowed under that program, as well as a new program called the Paycheck Protection Program, which authorizes the SBA to temporarily guarantee loans that may qualify for forgiveness for the full amount of the loan. As you've heard today, the CARES Act was intended to provide expeditious relief to employees and to small businesses. Next slide. I want to talk briefly about the Economic Injury Disaster Loan and the Emergency Advance. And I want to start off with some news hot off the presses. The SBA is no longer accepting applications for this particular program. They have run out of their allocation, at least they think they have, and so they've stopped accepting applications. The EIDL, as we call it, is the loan, but it also carries with it a loan advance of $10,000. Who qualifies? Small businesses, fewer than 500, including sole proprietorships, independent contractors, and self-employed persons, private nonprofit organizations, or 501c19 veteran organizations who are affected by COVID-19. As a footnote, as with everything involved in these loan programs, there are lots of exceptions to the rules, complicated rules, lots of dates, and lots of numbers. Certain businesses and certain industries can have more than 500 employees if they meet the SBA size standard for those industries. The EIDL advance is intended to provide economic relief to businesses experiencing a temporary loss of revenue and doesn't need to be repaid. So if you were to apply for an EIDL loan, you can keep the $10,000. You don't have to repay it even if you don't take the loan. So just some key points about the EIDL loan. There's no cost to apply, no obligation to accept it. Oh, next slide, sorry. There's no obligation to accept the loan. One of the nice things about the loan is it's unsecured up to $25,000. Collateral is required for loans more in excess of $25,000, and personal guarantees are required for loans in excess of $200,000. The maximum amount of the loan is $2 million. The interest rate for this particular loan is 3.75%. Payments are deferred for a 12-month period. This does have some underwriting requirements, including that the applicant have acceptable credit history and demonstrate an ability to repay. The EIDL loan, the uses permitted are payroll costs, fixed debt, or other bills that would have been paid if not for COVID-19. Next slide. Now I'm going to talk about the Paycheck Protection Program, which is a very exciting program for businesses. I want to provide also a hot off the presses update. On April 3rd, the SBA banks began accepting applications for the PPP loans. As of today, again, the SBA is no longer accepting applications because the allocation has been met, or at least they believe it will be. I wanted to just give you some interesting statistics about who's applied for those loans and who's been approved. I'll give you the top 6 states in terms of approval dollars. Texas has received the highest amount of approved dollars so far, just under $21 billion. Coming in behind Texas is California with just under $21 billion. Third after California drops down quite a bit to Florida with 12 billion roughly, then Illinois with roughly 12 billion, New York with just under 12 billion, and Ohio at 10 billion. In terms of the industries who have been receiving these loans, the number one industry is construction with just under $34 billion approved. Number 2, which is good for us, professional, scientific, and technical services with around 30 billion. Number 3 is manufacturing, also 30 billion. Number 4 is healthcare and social assistance at just under 28 billion. And number 5 is accommodation and food services at just under 23 billion. So that gives you just a little bit of background about who's getting the loans. In terms of the Paycheck Protection Program, what is it? The SBA was allocated $349 billion of forgivable loans up to $10 million per business. This is just a short overview. It covers 8 weeks of payroll and specified other expenses. In order to receive forgiveness of the loan, a business must maintain the workforce at its close to pre-pandemic pay and at close to the number of FTE pre-pandemic. It can't be used for pay in excess of $100,000 per employee, and for certain federal taxes or sick and family leave where credit is allowed under the FFCRA, which we've heard a lot about today. Next slide.
Laura, may I interrupt you there for a second?
Sure.
For an employee who makes over $100,000, can you still count them into the calculation for paying them up to the $100,000?
Yes. Yes, you can. And I'll talk about it a little bit later on, but there are some additional guidance with regard to that 100,000. What does it cover? So turning to who qualifies for a PPP loan, a small business concern as defined under the Act, self-employed individuals, an independent contractor, or any business, and this is where the CARES Act expanded the SBA's small business loan program. Any business concern, nonprofit organization, veterans organization, or tribal business that employs no more than 500 employees, or again, this is a caveat, where the particular business qualifies based on the standard number of employees established by the administration for industry. There's also an exception for hospitality and restaurant industries can have more than 500 employees. Turning to the next slide, there are a series of business entities that are ineligible to apply. For example, passive real estate businesses, entities that have defaulted on an SBA loan, lobbying businesses, obvious businesses engaged in any illegal activity. Some guidance has suggested that might include marijuana businesses. Next slide. The maximum, I'll just keep going. We're
a little bit of a
myself at that 14 minutes. Yes, I see that. I'm glad I'm not in control of the slides. That would be stressing me out. So the maximum amount of the PPP loan is 2.5 times the average total monthly payments for payroll costs incurred during certain periods. For those entities that are in business between February 2019 and June 2019, you're going to calculate that average payroll cost for the costs incurred in the year preceding the application. In addition, you can also include any outstanding disaster loan, including an EIDL loan. And so there are differences between the EIDL loan and the PPP loan. EIDL loan has a 3.75% interest rate. It has a longer period of time to pay. A PPP loan is going to have a 1% interest rate, but any unforgiven portion is going to have to be paid within 2 years. So it's just important to keep in mind. If an entity was not in business between February 2019 and June 2019, you're going to calculate your 2.5 times average total monthly payments for payroll costs on the period January 1st, 2020 and February 29th, 2020. And then the maximum amount of a PPP loan is $10 million. So Jules, if we could forward 2 slides, that would be great. So when you're calculating your payroll costs, what is included? So for an entity, as opposed to a sole proprietor or an independent contractor, you're going to include salary, wage, commission, or other similar compensation, but of course you're going to cut off at that $100,000 per year per employee. You can include cash tips. This is an important one. There's a lot of questions about whether vacation time is included or not. Vacation, parental, family, medical, or sick leave can be included. Allowance for dismissal or separation. Healthcare benefits can be included. Retirement benefits can be included, or the payment of state or local tax assessed on the compensation of employees. If you're a sole proprietor, next slide, the includable costs include income that is a wage, commission, income net earnings from self-employment, and that is an amount that is not more than $100,000 per year is prorated for the covered period. Now, when we're looking at this $100,000 cap for entities, it's important to keep in mind that that applies only to salaries and wages, but not to other costs like healthcare or retirement. So I've got a question about whether, since the SBA is no longer accepting apps for the loan, if a company has applied and that application has been assigned an ETRAN number, but they have not been funded yet, are they out of luck? And I can't give you a definitive answer on that. I do know that there's been a set amount that's been allocated. Banks have been allocated certain amounts, and I don't have an answer for that. It's a first come, first served basis. So when the money's out, the money's out. I think it just depends on where you're at in the process. Okay, excludable costs. What costs are excluded from your payroll costs? So there are some federal taxes, including taxes under Chapter 21, 22, or 24. Those are FICA, railroad tax, and unemployment. Compensation for non-U.S. residents. This is really intended to be directed at U.S. residents only. Qualified sick leave for which a credit is allowed under the Families First Corona Response Act, which we've talked about earlier, or qualified leave, family leave wages for which a credit is allowed under the Families First Coronavirus Response Act. And then for businesses, a business cannot include costs paid to independent contractors because independent contractors qualify for their own loans. What information, next slide, please. What information does a business need to have to provide during the application process? They need to provide certifications. They need to provide documentation showing salaries and payroll taxes were paid on February 15th, 2020, and that's important because the loans only apply to businesses that were in existence as of February 15th, 2020. Then they also need to provide payroll documentation showing average monthly costs for the preceding calendar year, including payroll processor records, tax filings, or 1099 if you're a sole proprietor. Next slide.
Let me stop you there for a second, Laura. I assume then that if you ran a house cleaning business or something kind of under the table, you're ineligible, right?
Well, house cleaning businesses, I believe, are expressly excluded from the who can get the loan.
Okay, but
So, yeah.
But something under the table, regardless of what it is, would be excluded. In other words, if you
wouldn't have the documentation necessary in order to receive the loan. You have to show that you're paying taxes.
Right. Okay.
It is tied to taxpayers in that way. There's a borrower certification, and I include that here for two reasons. One, because it's important to know what a company has to certify in order to get the loan, but two, because it's important to be thinking down the road. There are some potential risks if someone falsely certifies their application. So that there are 4 basic things that you need to certify. One is that this current uncertainty in our economic condition makes it necessary to support the ongoing operation of the company. 2, acknowledging that the funds are going to be used to retain workers and maintain payroll or pay the other allowable costs. And that's important because this is truly a loan program that's intended to keep workers employed. 3, that the eligible recipient doesn't have an application pending for a loan for the same purpose and duplicative of the amount applied for. It's very clear that while there are multiple ways that a business can be reimbursed for monies that are paid to employees during this economic crisis, there's no stacking of these various programs. In other words, you can't use the same event to cause you to get paid twice. There's no double dipping. And then the 4th certification is that during the period beginning on February 15th, 2020 and ending on December 31st, 2020, again, you haven't received amounts for the same purpose. So that's really important. There's lots of rules about no double dipping. So next slide. The terms. This is a very, very favorable loan. There's a 1% interest rate. Payments are deferred for 6 months. The loan can be entirely forgiven under certain circumstances, and we'll talk about those in a minute. The balance of any loan has a 2-year maturity, and this is just incredible. The amount that's forgiven is excluded from gross income. In other words, whatever amount is forgiven, you don't have to pay taxes on that. This is next slide. It's a non-recourse loan. There's no collateral required and no personal guarantees, which is another really an amazing part of this loan program. Next slide. So there are very specific permissible uses for this loan. First and foremost is payroll costs. Those are costs including wages, costs including group health care, sick leave, also retirement benefits. That's the first category. The second category is interest on any mortgage obligation. You can't include any prepayment or payment of principal on the mortgage obligation. So it's just what's due during the relevant period. The third is rent. And then the fourth is utilities. And then the final is interest on any other debt obligations that were incurred before the covered period. If the loan is used for unapproved purposes, the SBA is going to require the business to pay it back. If it's done knowingly, there will be prosecution for fraud. One way to think about how to proceed going forward is to open a separate account to track that you're using the expenses in the ways that are permitted. So this is probably the most important part of the Paycheck Protection Program for businesses who have already applied, and that is loan forgiveness. What amounts will be forgiven? First of all, let's talk about the period of time in which these costs must be incurred. The proceeds must be used in the 8 weeks after they are received to qualify for loan forgiveness. So that's a really important piece. If the money is spent outside of that 8-week period, under the statute and the guidance as it's written right now, there will not be forgiveness. Borrowers are eligible to have forgiven payroll costs, mortgage interest payments, again, not prepayment or principal payments, rent, and utility payments. The interesting thing is within the guidance, they've now allocated 75% will have to be payroll costs, and 25% can fit within that mortgage, rent, or utility payment. So as businesses are thinking about how they're going to spend this money, to the extent that forgiveness is a focus of the expenditures of this money, 75% needs to be on payroll costs. Next slide. There are limits on the amount of forgiveness, and the first limit is an obvious one: can't exceed the principal amount of the loan. The second one is there's a reduction in forgiveness based on the reduction in employees. So if a company started out with 100 employees and reduced down to 75 or 50 FTEs, there will be a reduction based on a formula that's set out in the statute and the amount that's forgiven. There will be a reduction in forgiveness based on the reduction in total salary or wages during the covered period, and the statute sets out how that reduction works. But it also adds an exemption for rehires. So where there's a reduction as compared to February 15th, 2020, and it occurs between February 15th and April 26th, 2020, and the reductions have been eliminated by June 30th, 2020, the statute and the guidance suggests that that cures the issues with regard to reduction in FTEs or reduction in salary, permitting forgiveness. Obviously, you're not going to get forgiven for amounts in excess of what were paid, but those are important considerations to keep in mind. And with that, I believe I've hit the 11:28 mark.
Everybody, this is John McMeekin, and I want to thank the panelists for one of the most informative seminars I've attended for an ABA event years. And I want to thank the participants. The questions that you all asked were good, insightful questions. Obviously, you're wrestling with these issues yourselves. And for those who asked the question, the materials will be put up. The panelists have some papers as well and some other materials that will be made available. The program itself will be available for rebroadcast. And as part of TIP's commitment to supporting legal practice and all the questions that you all have, if there is a desire to have a program like this again, there's a rumor that there'll be a second stimulus program. We'll be looking to convene something like this again. And if there's anybody else who has a subspecialty in some of the topics that we've talked about and would like to be a part of a secondary panel on a subtopic, please reach out to me and we will convene another program like this. And with that, Jewel Jones did a wonderful job of keeping us on time. And to the panelists, thank you very much. And everybody else, stay safe and healthy and indoors to the extent you can.